Hello friends, I am Dr. Vikas Agrawal, Assistant Professor, School of Law, Dr. Harishingor Vishwavidyalaya, Sagar. Today's topic of our discussion and learning is all about the Probation of Offenders Act 1958. The presentation in this episode will follow the following order: Module 1, Meaning and Concept of Probation; Module 2, Object of Probation; Module 3, Probation System in Other Countries; Module 4, Probation System in India; Module 5, the Probation of Offenders Act 1958, and the last module is about conclusion. The release of offenders on probation is a treatment device prescribed by the court for persons convicted of offences against the law, during which the probationer lives in the community and regulates his own life under conditions imposed by the court or other constituted authority, and is subject to supervision by a probation officer. The term probation is derived from the Latin word probare, which means to test or to prove. Etymologically, probation means I prove my worth. This is the system whereby the offender has to prove worthy of not being punished by his conduct. Simply, it can be understood as the conditional release of an offender on the promise of good behavior. Don M. Gottfriedson observed that probation is a procedure by which a convicted person is released by the court without imprisonment, subject to conditions imposed by the court. Thus, probation is first a reformative and rehabilitative form of sentencing directed at the convict who is amenable to reform, and second, it is a part of decision making process of judges at the time of sentencing. Probation is a conditional release of an offender under supervision. As a corrective measure, supervision can be used in two ways, namely before or after the custodial sentence. If it is applied to an offender before custodial sentence, it is known as probation. But if it is applied to an offender who has just been released from custodial sentence, then it is known as parole. The object of criminal law is more to reform the offender than to punish him. Instead of keeping an accused with the hardened criminals in a prison, court can order personal freedom on promise of good behavior, and can also order a period of supervision over an offender. This is what we generally know as probation. With the emergence of reformative theory of punishment, the Probation of Offenders Act has been enacted with a view to provide an offender the opportunity of improving his conduct so as to be able to live in the society. Its aim is the rehabilitation of the offender. If a chance offender is put in jail, he comes in contact with other criminals, and the chances of his being reformed and made worthy of living in the society are diminished to a great extent. In the case of Jugal Kishore Prasad vs. State of Bihar, the Supreme Court observed that the object of this act is to prevent the conversion of youthful offenders into obdurate criminals as a result of their association with hardened criminals of mature age, in case the youthful offenders are sentenced to undergo imprisonment in jail. America and England are the pioneer countries to introduce the statutory regulations regarding probation. The other countries have followed either American or British rules and techniques of probation. The position of the different countries is discussed below. First one, probation in U.S.A. The probation law was formally enacted in Massachusetts state for the first time in 1878, and probation officers were appointed for the city of Boston. The probation program was subsequently extended to other cities in the state of America. In course of time, juvenile courts were established, and the system of probation was extended to these courts also. By the middle of 20th century, probation became so popular that it began to be extensively used in cases of adults, juveniles and women in most parts of the United States. Illinois adopted the system of probation in 1899. Thereafter, other states followed the suit, and by the year 1956, all the states accepted probation for rehabilitation of the delinquents. The next country is UK. In UK, the system of probation received statutory recognition in 1907 with the enactment of Probation of Offenders Act 1907. At Birmingham, however, a separate court for the trial of teenage criminals was established earlier in 1905. The Probation of Offenders Act 1907 provided that an offender could be discharged on probation either after certain sentence being imposed on him or even before the imposition of sentence. His release on the probation could either be absolute or conditional depending on his antecedents, character, age, physical and mental condition and the circumstances which prompted him to commit the offence. Probation officers were separately appointed for adults and children. The Act was amended in 1908 and again in 1914. With the enactment of Criminal Justice Act 1948, probation was extended throughout England as a measure of correctional method of treatment. The next one is probation in New Zealand. New Zealand enacted early probation statute in 1886. The Act of 1886, which was limited only to first offenders, was replaced by the Probation of Offenders Act 1920. It is said to be the first country in the world to follow Massachusetts in making statutory provision for the introduction of a full-fledged probation system. The next is probation in Australia. In Australia, legislation was introduced in 1901 dealing with the conditional release of offenders on their own recognizance. The legislation was made to apply to first offenders and supervision was exercised by the police. In Australia, the adult probation has not developed into an official, full-time and professional service. However, full-time salaried probation officers are appointed for the supervision of adult probationer in Tasmania. The next is probation in Canada. In Canada, statutes regarding probation were enacted in early 1889. They were based on the British Probation of First Offenders Act 1887. A special legislation providing for the appointment of probation officers for the supervision of adult offenders was adopted in Ontario in 1922 and in British Columbia in 1946. The duty of probation officer is to carry out a preliminary investigation into the social and personal circumstances of convicted offenders. The next is probation in Japan. The Japanese Code of Criminal Procedure 1922 expressly stipulated the discretionary power of the public prosecutor in matters of suspension of prosecution and execution of sentence. The offenders, particularly the juvenile delinquents, are placed under probationary supervision. The system of granting probationary supervision to those who are granted suspension of the execution of sentence was fully introduced in Japan in 1955. Almost 20% offenders are allowed probation under supervision, while 80% are given probation without supervision. There is a network of probation supervision officers to look after the probationers. In India, probation received statutory recognition for the first time in 1898 through section 562 of the Code of Criminal Procedure in 1898. This section provided, in any case in which a person is convicted of theft in a building, dishonest misappropriation of property, cheating or any other offence under the IPC punishable with not more than 2 years imprisonment before any court and no previous conviction is proved against him, if it appears to the court before whom he is so convicted that regard being had to the youth, character and antecedents of the offender, to the trivial nature of the offence and to any extenuating circumstances under which the offence was committed, it is expedient that the offender be released on probation of good conduct, the court may, instead of sentencing him at once to any punishment, direct that he be released on his entering into a bond with or without sureties, and during such period not exceeding 1 year, as the court may direct, to appear and receive sentence when called upon, and in the meantime to keep the peace and be of good behavior. Section 562 was amended in the year 1923 so as to become wider in its ambit. The amended section was in the following terms: when any person not under the age of 21 years is convicted of an offence punishable with fine only or with imprisonment for a term of 7 years or less, and or when any person under 21 years of age or any woman is convicted of an offence not punishable with death or imprisonment for life and no previous conviction is proved against him, if it appears to the court before which he is convicted regard being had to the age, character or antecedents of the offender and to the circumstances in which the offence was committed, that it is expedient that the offender should be released on probation of good conduct, the court may, instead of sentencing him at once to any punishment, direct that he be released on his entering into a bond with or without sureties to appear and receive sentence when called upon during such period not exceeding 3 years, as the court may direct, and in the meantime to keep peace and be of good behavior. Section 562 subsection 1a made the provisions of conviction and release with admonition. In any case in which a person is convicted of theft, theft in a building, dishonest misappropriation of property, cheating or any offence under the Indian Penal Code punishable with not more than 2 years imprisonment or any offence punishable with fine only and no previous conviction is proved against him, the court before which he is so convicted may, if it thinks fit, having regard to the age, character, antecedents or physical or mental condition of the offender and to the trivial nature of the offence or any extenuating circumstances under which the offence was committed, instead of sentencing him to any punishment, release him after due admonition. The same provisions with regard to the probation and admonition were included under section 360 of the new code, that is the Code of Criminal Procedure 1973. The central government in the year 1931 for enacting a separate law for the release of offenders on probation of good conduct got a draft bill prepared, which was sent to the provinces for eliciting the opinion. However, the central government informed the provincial governments that they could enact their own laws as the central government would not go ahead with it due to heavy preoccupations. Consequently, some of the provinces enacted probation laws. After the Indian independence, the Probation of Offenders Act was enacted in the year 1958 by the Parliament of India. The central government, instead of implementing the act itself in the states, impressed upon them to adopt the act in the interest of bringing the uniformity throughout the country. Section 18 of the Probation of Offenders Act provides that this act will be applicable to those states only who have adopted it, and in all the other states section 360 of the CRPC will apply. Now we will discuss some of the important provisions of the Probation of Offenders Act. Section 1 of this act provides that it extends to the whole of India except the state of Jammu and Kashmir. Some of the important provisions of this act are covered under the following heads. The first one, power of court to release certain offenders after due admonition. Section 3 of this act deals with the admonition. It provides that when any person is found guilty of having committed an offence punishable under section 379 or section 380 or section 381 or section 404 or section 420 of the Indian Penal Code, or any offence punishable with imprisonment for not more than 2 years, or with fine or with both under Indian Penal Code or any other law, and no previous conviction is proved against him, and the court by which the person is found guilty is of the opinion that having regard to the circumstances of the case, including the nature of the offence and the character of the offender, it is expedient so to do, then notwithstanding anything contained in any other law for the time being in force, the court may, instead of sentencing him to any punishment or releasing him on probation of good conduct under section 4, release him after due admonition. The next point for the discussion is power of court to release certain offenders on probation of good conduct. Section 4 deals with the release of offenders on probation of good conduct. It provides that who can be released on probation, in what circumstances and under what conditions. Section 4 subsection 1 reads as follows: when any person is found guilty of having committed an offence not punishable with death or imprisonment for life, and the court by which the person is found guilty is of the opinion, having regard to the circumstances of the case, including the nature of the offence and the character of the offender, it is expedient to release him on probation of good conduct, then, notwithstanding anything contained in any other law for the time being in force, the court may, instead of sentencing him at once to any punishment, direct that he be released on his entering into a bond with or without sureties to appear and receive sentence when called upon during such period not exceeding 3 years, as the court may direct, and in the meantime to keep the peace and be of good behavior. Subsection 2 of section 4 requires the court, before releasing under subsection 1, to consider the report, if any, of the probation officer concerned in relation to the case. Subsection 3 provides for the supervision on the probationary. It provides that when a probation order is made, the court may, if it is of the opinion that in the interest of the offender and of the public it is expedient so to do, pass a supervision order directing that the offender shall remain under the supervision of a probation officer during such period not being less than 1 year as may be specified in the order, and may in such supervision order impose such conditions as it deems necessary for the due supervision of the offender. Subsection 4 empowers the court to require the offender to enter into a bond with or without sureties to observe the conditions specified in the order given under subsection 3, and such additional conditions with respect to the residence, abstention from the intoxicants or any other matter as the court may consider fit to impose for preventing a repetition of the same offence or a commission of other offences by the offender. The next point for the discussion is power of court to require released offender to pay compensation and costs. Section 5 makes provision for the victim compensation. This is a similar provision as is given under section 357 of the Code of Criminal Procedure. However, under section 357, the offender can be ordered to give compensation to the victim when he is sentenced. In case the offender is not sentenced but released on probation, then section 357 will not apply. In that situation, section 5 of the Probation of Offenders Act provides for the compensation to the victim of crime. It provides that the court directing the release of an offender after admonition or on probation may, if it thinks fit, make at the same time a further order directing him to pay first such compensation as the court thinks reasonable for the loss or injury caused to any person by the commission of the offence, and second, such costs of the proceedings as the court thinks reasonable. Subsection 2 provides that the amount ordered to be paid under subsection 1 may be recovered as a fine in accordance with the provisions of section 386 or section 387 of the Code of Criminal Procedure. The next point of this act is restriction on the imprisonment of offenders under 21 years of age. As section 4 provides for the release of offenders of any age on probation of good conduct, but that is a discretionary power of the court. Section 6 imposes limits on this discretionary power of the court and imposes a restriction on the imprisonment of offenders under 21 years of age. Section 6 provides that when any person under 21 years of age is found guilty of having committed an offence punishable with imprisonment but not imprisonment for life, the court by which the person is found guilty shall not sentence him to any imprisonment unless it is satisfied that having regard to the circumstances of the case, including the nature of the offence and the character of the offender, it would not be desirable to deal with him under section 3 or section 4, or if the court passes any sentence of imprisonment on the offender, it shall record its reason for so doing. The next point for the discussion is the appointment of probation officers. Section 13 deals with the appointment of probation officers. It provides that a probation officer under this act shall be first a person appointed to be a probation officer by the state government or recognized as such by the state government, or a person provided for this purpose by a society recognized in this behalf by the state government, or third, In any exceptional cases, any other person who, in the opinion of the court, is fit to act as a probation officer in the special circumstances of the case. Now, we will discuss the duties of probation officers. Section 14 of the Probation of Offenders Act provides for the following duties of the probation officers, that is, first, to inquire in accordance with any directions of a court into the circumstances or home surroundings of any person accused of an offence with a view to assist the court in determining the most suitable method of dealing with him and submit report to the court. Second, to supervise probationers or other persons placed under the supervision and, where necessary, endeavour to find them a suitable employment. Third, to advise and assist offenders in the payment of compensation or costs ordered by the court. Next, to advise and assist in such cases and in such manner as may be prescribed persons who have been released under section 4, or to perform such other duties as may be prescribed. At the end, we can say that the system of probation is the result of the reformative theory of punishment. It aims at the reformation and rehabilitation of the youthful offenders. This is a system which had worldwide acceptance, such as USA, UK, Japan, Australia, etc. In India also, probation system got recognition long back in the year 1898 under the Code of Criminal Procedure 1898 and under section 360 of the Code of Criminal Procedure 1973. And in the year 1958, a separate legislation was made in this regard, named the Probation of Offenders Act 1958. This act widened the scope of probation system and it deals with the detailed procedure of releasing an offender on the probation of good conduct. With all this information, here we come to the end of today's lecture. Do keep in mind what we have discussed today. It's time for you all to do some self-study. This is Dr. Vikas Agrawal signing off. If you want to learn more and enhance your knowledge, you may log on to our website for MCQs, quizzes, LORs, that is www.cec.nic.in. Till then, goodbye.